Hi, in this video, we're going to talk about medical negligence or medical malpractice in relation to res ipsa loquitur, or the concept of res ipsa loquitur. This is also a part of the outline of bar exams, and in law school, this is under the topic of quasi-delicts or torts. Now, before we begin, again, we'd like to remind that this video is not intended as a substitute for legal advice. This is for educational purposes only. If you have any concerns in relation to this video, please call a lawyer. Now, the elements of medical negligence: number one, there's a duty or standard. Second, there's a breach. Third, there's an injury on the part of the patient. And number four, there's causal connection or proximate causation, connecting the act of the doctor and the injury of the patient. And there's the definition as well. The definition somehow contains the elements. Medical negligence, aka medical malpractice, is a claim that seeks to address a wrong committed by a medical professional that results in bodily harm or the death of a patient. So, the elements, lagyan mo lang ng claim, it becomes the definition. So, a claim is a concept under civil law, or quasi-delicts as well, that arises from an obligation. Just to recall, in law school, there are 5 sources of obligation: law, contracts, quasi-contracts, delicts, and quasi-delicts, or torts. Medical negligence is a source of obligation where the obligor, or the person obliged to give, will be the doctor if proven, and the obligee, or the person entitled to the obligation, is the injured patient. Now, claims in civil cases can arise from various sources, such as quasi-delicts, etc., as we have said. And medical negligence arises from quasi-delicts. The term torts, by the way, may sometimes be synonymously or alternatively used, but torts is a common law term which is more broad. It's broader compared to the term quasi-delict. I think quasi-delict is a civil law concept, while torts is a common law concept. Now, quasi-delict is an act of fault, negligence, or omission which causes damage to another without pre-existing contractual obligation, meaning there's an action, second, there's damage, there's injury, but they have no contract. There's no agreement between there's no prior agreement between the parties that they will compensate. Unlike an insurance contract, for example, which is contractual by nature, quasi-delict is by nature without prior or pre-existing contractual relations. Now, when we say act of fault, there's also the element of voluntariness. Okay, because if a person did not act voluntarily, then he will not be liable. Also, under the revised penal code, crimes can be, or felonies can be committed by either dolo or culpa. Dolo means intent, malice. Okay, so for example, homicide, murder, rape, those are committed with malice, with bad intent. And the other way of committing a crime is through negligence. So in negligence, there's no mens rea, there's no criminal mind, there's no intent to cause a wrong. However, the person will be held liable not because he had this bad faith, not because he has this evil intent, but he is punished because he failed to exercise proper precaution. He had this lack of foresight or lack of skill, which ordinary prudent men should have had. Therefore, he will be penalized under quasi-delict. So again, the elements of medical negligence are standard or duty. It is a standard of behavior that imposes restrictions on one's conduct, requiring a physician to use the same level of care that any other reasonably competent doctor would use under the circumstances in a doctor-patient relationship. The second is breach. So when you say a breach, it simply means a violation. It's it's a disobedience in per se. In common language, you've disobeyed the standards, the law. Somehow in the realm of medicine, they have these laws. They're internal laws, which under the realm of law is called standards. Okay, for example, if you are a surgeon or if you are an internal medicine, if you are an ENT, when you check up, when you check up patients, when you operate a patient, you are bound by not just by Hippocratic oath, but you're also bound by the current latest standard procedures of that certain discipline. So when in surgery, if the patients manifest these symptoms, then you have to perform these sets of procedures. So these are what we call standards. So it's very important to have standards because this will be the basis on which the medical professional will be judged. Now, breach, again, it's a violation. And second, there's injury because there will be no medical negligence if the patient did not suffer injury. But the meaning of injury is that the patient, okay, suffered harm, suffered injury, and could even be death. And the last, which is very important, there must be proximate causation, meaning there is it's the action of the doctor has set in motion natural sequence of events, okay, without efficient intervening cause, meaning it is really the cause of the effect. And this is where we can also get or discuss deeper the term of res ipsa loquitur. Now, let's dive deeper into each of the elements quickly. So first is standard of duty. Standard of duty, the physician owed a duty of care to the patient. So the very first thing that must be established is that the doctor is obliged to care for the patient. There must be a patient-doctor relationship. If if there is no patient-doctor relationship, then the doctor is not obliged to care or to provide care for the patient. Now, this is also subject of a lot of Supreme Court cases, not just in the Philippines but also in the U.S. The question of whether or not there is a patient-doctor or doctor-patient relationship. However, let's look at some real world examples. Number one, when the patient or his parents sought the medical services of Dr. Kasumpang and the latter knowingly accepted Edmer as a patient. Dr. Kasumpang's acceptance is implied from his affirmative examination, diagnosis, and treatment of Edmer. GR 171127. So the moment the doctor accepted, diagnosed, examined, and treated a patient, then this PDR, let's just call it PDR, this PDR is established. Whether or not there is payment, I believe so. For me, even though there's no payment, the moment the doctor examined, treated, there's a PDR. Second example, GR 171127 still, but I think this was quoted. When Dr. Miranda assumed the obligation to provide resident supervision over the latter. I'm not really familiar with the residency of doctors. Maybe I may study it, but residency, maybe they're, I don't know, maybe it's internship. It's analogous. I don't know. Just tell me in the comments. But he is a second year resident doctor in a certain hospital, and the task of Dr. Miranda is to do rounds and assist other physicians who participated in the diagnosis and prescribed a course of treatment for Edmer. So the Supreme Court said there's a PDR in this case because even though he or she he's doing rounds and a resident doctor, then there's this PDR. And lastly, a U.S. case of Mead versus Legacy Health System. The court considered the rendering of an opinion in the course of the patient's care as the doctor's assent. So the moment the doctor gave his opinion, medical opinion, then a PDR has been established. So these are the cases that the moment you gave advice, the moment the doctor treated, diagnosed, or ordered a lab, for example, then there's PDR. The doctor now has the duty to provide care. Luke 5:30, we know that Luke or Saint Luke is the one of the 12 apostles who was a doctor. He quoted the Messiah saying, "Those who are well do not need a physician, but those who are sick." This is, although this is a medical statement, but actually the Messiah was actually saying to the self-righteous people, "Hey, I did not come to heal the healthy. I came to heal the sick." But actually, what the Messiah meant was that all of you are sick. Even though you seem religious, even you are a religious or healthy, seemingly healthy person, you are still sick. And I came to heal you. But sadly, those Pharisees refused because for them they're already good. So that's actually the problem of so many people. They think they are healthy. They think they are good. They think they don't have a sickness. That's why they don't come to the doctor. When will you come to the doctor? Of course, when you acknowledge that you are sick. That's the same way with spiritual condition. We cannot come. There is no salvation if we do not first acknowledge that we are sick spiritually and we need a doctor. We need a Messiah. We need a Savior. That's why also the same with patient-doctor relationship. If the patient did not seek for advice, for consultation, for the help of the doctor, then there's no PDR. Also, if there's no contract, no, it's not a defense that there's no pre-existing contract because again, this is a quasi-delict. The court emphasized that the absence of a contract does not negate the PDR. This is in De Jesus versus Oyluan in a very recent case, 2022. Now, as to the duty, it means expected behavior for the doctors, expected procedures, expected treatment, regimen of treatment that they should adhere to. The minimum standard of care that any other competent doctor would use under the same circumstances. In one time, I was in Riverside, and then I think I had this PT session, and then gin-BP ako, and then sabi ko, wag na lang yung BP kasi matagal pa yan. Parang ganun. So, nagmamadali ako that time. Sabi ng PT, no sir, this is protocol. That's why I placed there the word protocol because in the medical, I'm not a medical by undergrad, but I think the same way with any other professions, they are bound by these protocols. The moment they divert, the moment they disobey, they violate, they breach, then they would be in hot water. Okay, how is duty or standard established? So every case, every patient situation has this set of symptoms, for example, and there's a corresponding standard how doctors should respond. And in the court, in case there's an accusation against a doctor, how will it be proven that a certain standard has to be this and should be followed by the doctor? It will be proven by an expert testimony. Expert testimony establishes the standard of care, providing the defendant's conduct whether or not he fell or complied with the standard. It demonstrates that the failure to observe the standard caused injury often requires expert testimony due to the technical nature of medical malpractice cases. Tandaan na, the word is requires expert testimony generally because there are exceptions, and that is the concept of res ipsa loquitur, and also another exemption is patient's fault. Now, exception 1 is res ipsa loquitur. It's a Latin word which means res means thing. Ipsa, I think it means speaks because I think we got the Ilonggo word there, hipsan. No, hipsan means to do not speak, but in Latin, I think it speaks. And then loquitur, we have also another Ilonggo word for lokit, which you punch or you put a hole on a thing. So the thing speaks for itself. And what does that mean? Meaning that expert witness or expert testimony is no longer needed when the failure to observe due care is readily apparent to a lay person. Very obvious na this should have been done. but it was not done. No need to resort to another expert doctor, but just common layman knowledge would dictate that the doctor fell below the medical standards, where negligence is apparent from the injury itself. Another exception is patients act as the proximate cause. Doctors, according to Supreme Court, doctors are not guarantors of care and are not insurers against mishaps or unusual consequences, especially if the patient did not exercise the proper diligence to avoid injury. So doctors are not superheroes. They are not the Estes, if you know what I mean. They are not the absolute guarantor of our health. If you come to the doctor and if the patient is already terminal in illness, or the patient is neglectful of his or her health after the doctor gave him advice, then the proximate cause principle applies. We will discuss that more later. Now, the second element is breach, meaning there's a standard, but the doctor failed to comply with that standard. Breach of professional standard means failure to comply, and it also need evidence must be presented that the physician failed to meet that standard. Also, expert testimony must be provided. Maybe the hospital records, maybe witnesses. Those are the ways. And we will look at some real-world examples. Doctors Kasumpang versus Cortejo. Here, the doctor operated the patient without foreseeing the harm. So the Supreme Court says, when a patient exhibits symptoms typical of a particular disease, these symptoms should, at the very least, alert the physician of the possibility that the patient may be afflicted with a suspected disease. The court also ruled that reasonable prudence would have shown that diabetes and its complications were foreseeable harm. However, the petitioner doctors failed to take this into consideration and proceeded with the DNC operation. I did not research what is DNC operation, but somehow this case the doctors just operated the patient without maybe like analyzing the diabetes condition, okay, and the possible reactions of that when you operate the patient. And thus, they failed to comply the duty to be given to a hyperglycemic or diabetic patient. So, okay. I remember I have this relative that has diabetes, and when they have wounds, medyo matagal. No? It takes time to heal. Maybe that's I am not really went deeper, but maybe that's the reason why the patient suffered injury. Diabetic. So another case is failure to refer. In Harcia versus People, the court found that doctors who merely passed by and were requested to attend the patient were liable for malpractice. So, dinaanan nila ang patient, ni-request silang i-examine, and it was established that they had the PDR. And later, assured the mother that everything was fine. So, ito yung nagawa nila. They said, oh, everything is fine. The court said that they committed breach because they just said, you're fine. I think the reason nila is hindi sila competent, no? Assuming that they did not have the capacity, okay, wala silang tools at that time, they should not have said everything was fine. They should have referred the patient to another hospital or doctor to make sure that everything is all right. Another case is when the doctor failed to detect and manage. So in confirming bronchopneumonia, Dr. Kasumpang selectively appreciated some and not all of the symptoms presented. He failed to promptly conduct the appropriate tests to confirm his findings. In some, he failed to detect dengue fever. So there will be breach if the doctor did not order appropriate tests. It will be a different story if the patient did not take those tests, but as long as the doctor ordered tests and appreciated all symptoms, then he's fine. But failure to order such is considered a breach. Also, another but this time a defense, a valid defense, would be bona fide error of judgment. We clarify the court said that a wrong diagnosis is not by itself a medical malpractice. Physicians are generally not liable for damages resulting from a bona fide error of judgment. Nonetheless, when the physician's erroneous diagnosis was the result of negligent conduct, neglect of medical history, failure to order the appropriate tests, failure to recognize symptoms, it becomes an evidence of medical practice. So the way I see this is that it's not it's not a liability if a doctor commits wrong diagnosis, provided that the wrong diagnosis was free from negligence. In other words, the doctor considered all these symptoms, for example, ordered all these tests, and there could be two possible results, and he just chose one over the other. Pag nag-choose siya ng one and the result pala is the result number 2, it's not actionable provided that he has done all these orders or actions. Another is bona fide errors must still follow certain standards. Medicine is not an exact science according to the Supreme Court. Doctors are not expected to give 100% accurate diagnosis in treating patients who come to their clinic. Error is possible, as the exercise of judgment is called for in considering and reading the exhibited symptoms. But in doing this, the doctor must have acted according to acceptable medical practice standards. So kahit may error, it's not actionable as long as it's still within acceptable medical practice standards. So yun na lang ang tanda natin. Again, failure to order the appropriate tests and recognize symptoms is considered breach. Let's go to the third element, injury. In other words, the patient suffered harm. What are the examples of injuries suffered by patients? Comatose and brain damage, Ramos versus CA. Foreign objects left in the body, such as 2 pieces of gauze, causing further complications. Brain damage at 3 years old. May unsterilized medical instrument during surgery left in the body and caused infection. Agbayani versus Director of Manila City Jail. And death after routine appendectomy. So, res ipsa loquitur, dito na, no? Ang injuries may not need expert testimony when the doctrine of res ipsa loquitur applies, meaning the injury is apparent to the lay person, and every lay person can conclude that this is connected with the negligence or the action of the medical professional. I quoted this from Attorney Raylan Garcia in our law journal. I also have an article there. But according to Attorney Raylan, rationale and purpose of res ipsa loquitur is to narrow down the quantity of evidence that the suffering patient or the injured patient has to submit. So this is also in favor of the injured patient. No need na siya present ng mga medical or health professional or health expert to prove the injury. Kasi I think I can remember, if I can remember correctly, during the seminar, nahihirapan or mahirap para sa kumbaga mga lowly people na mag-access sa mga matataas sa society like the doctors. Kasi marami din minsan yung mga doctor, syempre, they will save their faces. They will not testify against their other doctors kasi they have this common saying na maliit ang mundo, no, the medical profession is very small, you know, maybe that will breed contempt within their circle. So the Supreme Court laid down the principle of res ipsa loquitur so that those obviously, patently obvious injuries and negligence can be proven in court without needing expert testimony. It also relieves the plaintiff of the difficulty of finding a medical professional who would testify against a fellow medical professional. Yeah, as what you've said, among others. So there are also other reasons for invoking res ipsa loquitur. However, res ipsa is not applicable if the death of the patient or the injury of the patient is not manifestly identifiable, that it is related to the action. For example, the declared cause of death of Marisa is cardiorespiratory arrest secondary to hypovolemic shock, placenta accreta, TC amniotic fluid embolism. So see, manunosebleed ka niyan, di ba? Placenta accreta is not the contemplated scenario to justify the application of the doctrine of res ipsa loquitur, as this kind of complication in childbirth is not immediately apparent and oftentimes not immediately diagnosed. So, to prove that there's liability, kailangan ng expert testimony dito. Kasi hindi siya immediately apparent na ang hypovolemic shock, placenta accreta is caused by the action of the medical professional. Kasi baka this could be, in layman's term, inborn na sa patient. Baka this is already pre-existing even before she gave birth. Maybe this is already existing within her, and expert witness should or would analyze, yung hypovolemic shock et al. Nito is not related to the action of the medical professional during the childbirth. Therefore, is not guilty. Or the expert professional can also conclude that the action of the doctor led to hypovolemic shock, fluid embolism, etc. So that's res ipsa loquitur. Reyes versus Sisters of Mercy Hospital. Sabi ng court, res ipsa loquitur is applicable in Ramos case because mental brain damage does not normally occur in a gallbladder operation. Yun na lang. So, ang operation is gallbladder. Ang injury ng patient is brain damage. So, obviously, any person, kahit hindi doktor, can say that it's not the gallbladder disease of the patient that caused his mental brain damage. It is the action of the anesthesiologist. Okay. However, in this case of Reyes versus Sisters of Mercy, in this case, while it is true that the patient died just a few hours after professional assistance was rendered, this shows that he had been suffering from a serious illness and professional medical help came too late for him. So, paano ma-prove na ang cause of death niya ay hindi dahil sa professional assistance ng mga physicians? It needs expert witness. It needs an expert advice, an expert to look at it, na hindi kinos ng doctors ang kanyang kamatayan. It is caused rather by a pre-existing condition of the patient. Now, let's look at the last element, that is proximate cause. There's a causal link between the breach of the doctor and the injury of the patient. It is the burden of the patient to plead and prove not only that he has been injured and defendant has been at fault, but the patient has to prove that the defendant's fault is the proximate cause of the injury. A verdict in malpractice action cannot be based on speculation or conjecture. Kasi kawawa naman ang mga doktor pag lahat na lang ng mga injury i-associate sa kanila or i-attribute sa kanila. There has to be a proximate cause. Means that cause that sets in motion. So ito yung legal meaning talaga ng proximate cause, no? There's a cause, there's an action that has set in motion a series, okay, of events, a direct and natural chain of events that leads to the patient's injury, unbroken by any efficient intervening cause. The causal link between the breach and the injury or death. It must be the legitimate consequence of the wrong done. This is established by expert testimony. In order to establish the proximate cause by a preponderance of the evidence in a medical malpractice action, the patient must similarly use expert testimony, because the question of whether the alleged professional negligence caused the injury is generally one for specialized expert knowledge beyond the ken of the average layperson. So here, in this case, failure to remove the gauze caused the injury. When the healthcare provider's breach of duty directly results in the injury, the court held that the lead surgeon's failure to remove foreign objects from the patient's body during surgery and his subsequent concealment of this fact constituted negligence. So, I think may infection no sa case na to kasi naiwan yung gauze and then tinago lang ng doktor. Hindi niya ni-report, hindi siya gumawa ng action para i-remove uli yun. The court said this is the proximate cause. May isang case din na nag-rule ang Supreme Court na walang proximate cause. Kasi yung doctor, si Dr. Tuanyo, I think he is an ophthalmologist, he gave Maxitrol to Peter. And later on, Peter developed EKC. I think this is glaucoma. But the court said this was not the proximate cause because Maxitrol or neomycin polymyxin B sulfates dexamethasone ointment is a multiple dose anti-infective steroid combination in a sterile form for topical application. Walang proximate cause kasi maybe the expert witness would have established that this is the standard procedure. Okay? And this is not really the proximate cause. Now, maybe glaucoma is really like hereditary na no sa kay Peter. And the last, where there's no proximate cause still, dito sa case na to sa Cayaw Lasam versus Spouses Romulete, ang nangyari is hindi bumalik yung patient for follow-up. Okay? And nag-rupture yung kanyang uterus. So the court said, walang proximate cause kasi merong efficient intervening cause. Ano yun? Yung hindi pagbalik sa follow-up. So, nung hindi siya bumalik for follow-up, sumabog yung uterus niya. Okay? That's why the doctor is not liable. Thank you very much for watching. That's all. If you have questions, feel free to comment. And again, this video is only intended as an educational video and not intended for medical or legal advice. If you have any, please call a lawyer. Thank you. God bless. Bye-bye.